Senator from Iowa.
We have a very bad regulation that's been put out by Social Security Administration that needs to be obliterated, and so we're using the process called the Congressional Review Act to show Congress's displeasure with Social Security and to get this regulation off the books. Now, there's been a lot of talk about how this Congressional Review Act is a wrong vehicle to repeal the disastrous regulation. So I want to quote a contrary opinion from the National Coalition for Mental Health Recovery saying this, quote, "The CRA," meaning the Congressional Review Act, "the CRA is a powerful mechanism for controlling regulatory overreach, and the National Coalition for Mental Health Recovery urges its use advisedly and cautiously. In this particular case, the potential for real harm to the constitutional rights of people with psychiatric and intellectual disabilities is grave, as is the potential to undermine the essential mission of an agency that millions of people with and without disabilities rely upon to meet their basic needs. Therefore, in this instance, the NCMHR feels that utilizing the Congressional Review Act to repeal the final rule is not only warranted, but is necessary," end of quote. And I would add to that, obviously necessary. So, Mr. President, I'd like to enter that letter into the record.
Without objection.
There's also been talk about how supposedly dangerous it will be if this Social Security regulation is terminated. I don't see how that can possibly be realistic if the Social Security Administration doesn't even determine a person dangerous in the first place, and dangerous in regard to whether or not they ought to be able to make use of the constitutional right of Second Amendment to own and possess firearms. Now, others in this debate continue to mention that mentally ill people will be able to acquire firearms. Now, very important, the Social Security Administration does not determine a person to be mentally ill prior to reporting their names to the gun ban list, which, being on the list, denies you your constitutional rights. The agency has confirmed this in writing to my office. Quote, "Yes, you are correct. The Social Security Administration does not diagnose individuals as mentally ill," end of quote. Supporters of this gun ban fail to address why individuals are not provided formal due process before reporting their name to the list. Supporters have also failed to talk about how the regulation is inconsistent with the statutory standard of quote-unquote mental defective. An existing statute requires agencies to report individuals to the gun ban list who are ineligible under current law from possessing firearms. That requirement does not require the existence of any regulation to be effective. So it is plainly wrong to claim, as was said this very day by the people opposed to what we're doing, that if the regulation is disapproved, agencies will no longer have to report prohibited persons. The reverse, in fact, is true. The regulation usurps unlawful authority to report people to the gun ban list who are not barred from owning guns under current law, and that the agency is prohibited from reporting under current law, especially without the adjudication that is required under current law. Opponents of the regulation base their opposition on the language of the regulation, existing law, and the Constitution, citing the Constitution to say you don't have a constitutional right to own arms under the Second Amendment is contrary to two recent Supreme Court decisions that verify that that applies to an individual. That is why the regulation's supporters must resort to arguments that lack legal and factual foundation. Supporters of this gun ban also fail to address how overly broad this regulation is as written. It will capture innocent Americans, denying innocent Americans their constitutional rights. And sadly, then, we know how this will play out if this regulation were allowed to go forward, because we have the example of the Department of Veterans Affairs reporting hundreds of thousands of veterans to the National Institute Criminal Background Check System without adequate due process. And that's the same system that Social Security was going to report people to. Now, veterans were reported just because some lonely bureaucrat wanted to report them with no opportunity to first have a neutral authority hold a hearing finding that that individual is dangerous or actually have a dangerous condition. These were veterans that needed financial help managing their benefit payments. Now, it's common sense that needing help with your finances should not mean that you have surrendered a fundamental constitutional right of self-defense that you have under the Second Amendment. So just like the Social Security Administration, the VA does not determine whether a veteran is dangerous before reporting his name to the gun ban list and denying that veteran his Second Amendment constitutional rights to own and possess firearms. The VA regulation is eerily similar to what the Social Security Administration wants to do. On May 17, 2016, Senator Durbin and I debated my amendment that would require the Department of Veterans Affairs to first find veterans to be dangerous before reporting their names to the gun ban list. Now, that's common sense, isn't it? You ought to find out, are they really dangerous before they're denied a constitutional right? During the course of that debate, Senator Durbin admitted that the list was broader than it should have been. He said, and I quote, "I do not dispute the senator from Iowa suggested that some of these veterans may be suffering from mental illness not serious enough to disqualify them from owning a firearm, but certainly many of them do," end of quote. Senator Durbin also said, quote, "Let me just concede at the outset, reporting 174 names goes too far, but eliminating, as my legislation proposed to do, eliminating 174,000 names goes too far." For the record, though, it wasn't really 174,000 names going too far. It was actually 260,381 names from the VA sent to the gun ban list. Now, that happens to be 98.8% of all names that are on the list because of alleged mental defectiveness. The Department of Veterans Affairs reported more names by far than any other agency without sufficient justification. Senator Durbin's staff and mine have met over these issues since that debate, and I appreciate and thank him for that outreach. But now we have this Social Security Administration problem, and through the Congressional Review Act, we can do something about it. We don't have to pass a separate piece of legislation like we're going to have to do to straighten out the VA. So the Social Security Administration is about to make the same mistake as the VA unless we stop it right here and right now. And if this regulation is not repealed, the agency has informed my staff that approximately 15,000 to 75,000 beneficiaries of Social Security may be reported annually, denying them their constitutional right to bear, possess, and own firearms. And that figure of 15,000, or even more so, the higher figure of 75,000, will add up very quickly. In my earlier speech today on this topic, I made clear that the agency regulation is defective in many ways. Namely, the regulation does not require the agency to find a person dangerous or mentally ill. The regulation also provides no formal hearing before a person is reported to the gun ban list. Supporters have also said that repeal of this regulation will interfere with enforcement of gun prohibition laws. Such a position is without any merit, denying people constitutional due process. As I made clear in my earlier speech, important federal gun laws are still on the books, even if the agency rule is repealed. And this is so because this new regulation is actually inconsistent with those existing federal gun laws. For example, individuals who have been determined to be dangerous or mentally ill will be prohibited, as will those convicted of a felony or a misdemeanor crime of domestic violence. The same for those involuntarily committed to mental institutions. While discussing the faults and defects of the rule, I think it is important to highlight that the issues pointed out are also the solution to the problem. If the supporters of the agency rule wants the Social Security Administration to report individuals to the gun ban list, changes need to be made. Individuals must first be determined by a neutral authority after a fair hearing meeting the requirements of the U.S. Constitution. If they're dangerous and have dangerous mental illness, then they could constitutionally be denied that right. Constitutional due process is a very important part of that process. If we do not act, the agency will erroneously report tens of thousands of people per year to the gun ban list. Not one of them will have been adjudicated to be dangerous after a hearing with due process. Not one of them will have been adjudicated to be mentally ill after a hearing with due process. And all of them will have had the government's burden shifted to them to prove that they're not dangerous in order to get their name off the gun ban list. Common sense, isn't it? You ought to be, you're not guilty until proven innocent. If you can't have a gun, common sense tells me you ought to not to have to prove that you can have a gun to the government. The government's got to prove you should not have a gun. Any way you look at it, the regulatory scheme is patently unfair. If the government wants to regulate firearms, it needs to produce a clearly defined regulation that is very narrowly tailored to identify individuals who are actually dangerous and who actually have a dangerous mental illness. The government must also afford constitutional due process. What we're dealing with here is a fundamental constitutional right backed up by 2 Supreme Court decisions in the last 10 years. With that type of constitutional status, the Second Amendment requires greater effort and greater precision from the government in order to fairly regulate how the American people exercise that constitutional right. This regulation simply doesn't meet that standard. I urge my colleagues to support the resolution of disapproval. Mr. President, I don't know whether anybody else is coming to seek the floor or not, and if I'm infringing upon somebody else's time, I will yield the floor. But in the meantime, I would ask permission to speak as if in morning business.
Without objection.
I rise today to discuss some criticism I've heard about the nominee to fill the seat on the Supreme Court. That nominee is Neil Gorsuch. My colleague, the minority leader, last week met with the nominee. Afterwards, he told reporters that he had, quote, serious concerns about the judge. Well, I guess I shouldn't be surprised. After all, it seems the minority leader had concerns about the nominee even before the nominee was announced. Before Judge Gorsuch was announced, the minority leader made clear that any nominee must be, quote unquote, mainstream. But it became clear immediately that this nominee is widely regarded as a mainstream judge with impeccable credentials. Liberal law professor Lawrence Tribe says that, quote, he's a brilliant, terrific guy who would do the court's work with distinction, end of quote. Alan Dershowitz, who certainly is no conservative, says Judge Gorsuch will be, quote, hard to oppose on the merits, end of quote. Even President Obama's acting Solicitor General, Neil Katyal, said Judge Gorsuch, quote, would help to restore confidence in the rule of law, end of quote. Now, the chorus goes on, Mr. President. Well, apparently because the nominee is so obviously mainstream, the benchmark for my colleagues' concerns keeps changing, moving the goalposts. The minority leader has conveniently developed a new test. Now he says that the benchmark is independence. Quote, the bar for the Supreme Court nominee to prove that they can be independent has never been higher, end of quote. Well, fortunately for the minority leader, the nominee passes that bar with flying colors, just like he passed the mainstream test with flying colors. The nominee's record makes clear that he's an independent and fair-minded judge who's deeply committed to the separation of powers. Here's just one example from his many opinions on that point. Just last year, Judge Gorsuch had to decide a case about authority of the Board of Immigration Appeal, BIA for short, which answers to the Attorney General. The BIA wanted to change the Attorney General's power to waive immigration requirements for illegal immigrants, and it wanted the new rules to apply to undocumented immigrants whose waiver applications were already in the works. The nominee said no to this executive agency. To be clear, Judge Gorsuch was asked to decide whether an executive agency in charge of an immigration law could change the law on a whim in a way that many believed was unfair to immigrants who had already sought waivers. He said no. With due respect to my friend, the minority leader, there's no doubt that Judge Gorsuch would say no to this or any other part of the executive branch that oversteps its bounds. Here's what the nominee wrote about the separation of powers and the executive branch and the executive branch overreach. For him to defer to the executive agencies in that case would be, quote, more than a little difficult to square with the Constitution of the framers' design, end of quote. That's because doing so would allow agency bureaucracies to, quote, swallow huge amounts of core judicial and legislative power, end of quote, which the Constitution assigns to separate branches of government. So the nominee was concerned about the separation of powers. He was concerned about people whose liberty might be impaired. And because of those concerns, he said no to the immigration agency's policies whim of the day. Judge Michael McConnell, a former colleague of Judge Gorsuch on the 10th Circuit, makes the same observation about this case. He says the scope of executive power arguably, quote, will be the most prominent Supreme Court issue of the coming decade, end of quote. He said the nominee analyzes that issue in a way that's faithful to the Constitution and to the independence of the judiciary, and he points to the nominee's thinking on this question. This is what Judge Gorsuch wrote, quote, what would happen if the political majorities who run the legislature and executive branches could decide cases and controversies over past facts? They might be tempted to bend existing laws, to reinterpret them. This would risk the possibility that unpopular groups might be singled out for this sort of mistreatment, or would raise along the way to grave due process, fair notice, and equal protection problems. It was to avoid dangers like these, dangers the founders had studied and seen realized by their own time, that they pursued the separation of powers. Sounds a little bit like you'd find stated in the Federalist Papers on the role of a judge and the separation of powers. What I just quoted was the nominee's words. That's the writing of an independent judge who believes in separation of powers. You know, there's a bit of irony in some of the criticisms I've heard leveled against Judge Gorsuch. On the one hand, I've heard that we have to make sure that he'll be independent and that he won't rubber stamp the president's agenda. On the other hand, I've heard he'll be way too tough on the executive branch as it fulfills the president's agenda. Well, it's quite obvious. Common sense tells you you look at those two arguments, you can't have it both ways. Judge Gorsuch has shown he is faithful to the separation of powers in the Constitution. That means he will be an independent judge who will say no when the other branches of government overreach. And you don't need to take my word for it. Listen to President Obama's acting Solicitor General, Neil Katyal. He's no fan of the president's executive order, but he says that Judge Gorsuch, quote, will not compromise principle in favor of the president who appointed him, end of quote. Instead, that Solicitor General said the nominee, quote, would help to restore confidence in the rule of law. Judge Gorsuch's record and reputation have no room to doubt that leave no room to doubt that he's a mainstream independent judge. He'll apply the law fairly, and he won't be afraid to say no when the Constitution requires it. Every time my colleague, the minority leader, has set out a standard for filling this Supreme Court seat, this judge has met it. He's mainstream, he's independent, And when my colleagues chooses a new standard, I'll bet that the nominee will also meet that new standard. And the more of these faults that are pointed out, the stronger this candidate for the Supreme Court's going to come. I yield the floor.